judge?
Yeah, there is an issue now which is very apparent for anyone to see. It is very apparent that having gone multi-party, there's a spirit of the movement system which still lingers on in our constitutional order. Under the regime of one-party state dictatorship, it was the position that the judicial arm of government or judges were being appointed by the sitting president. But having gone to under the multi-party dispensation, it is wrong that that obligation and duty was left in the hands of a sitting president, because he is partisan in matters which touch political parties. If you are head of one political party, being charged with the duty of appointing judges, what happens to matters which are against your political party? Apparently, there will not be impartiality in such a situation. It has been a clarion call that it is long overdue that judges should not be appointed by a leader of one political party. A judge who will preside over matters against that political party will not be free. It even becomes worse, where we have now an unconstitutional position of appointing acting judges on probation. So what do you expect of a judge awaiting a signature of a leader of another political party in a matter where that political party is before that judge? It is very apparent that there will be bias. It is very apparent that that judge will be uncomfortable, will not even dare make a decision against the appointing authority pending that signature of confirmation. So that is a lacuna, that is a mischief which needs to be corrected. First of all, it is not necessary to have acting judges. It is wrong at law, even wrong logically. You cannot have an acting judge. It is not provided for anywhere. It is an abuse of process of appointing judges. Secondly, the appointing authority should no longer be a sitting leader of a political party in power. It's apparent it would be subject to abuse. Even if someone would say, I'm not biased, it's not enough for you to say, I'm not biased. Justice is not only done, but it has to be seen to be done. The rationale is, what would a reasonable person think if such a matter is before a judge who is left probably with 1 year to be confirmed by a signature, which judge still has to make a decision against or for or against the appointing authority. It is apparent bias which should really be checked. But now that the powers of checking power or balancing power, the balance of power, one arm is pushing and exerting pressure on the other, there cannot be democracy. There needs to be a separation of roles and powers. But the overlapping powers where the executive is exerting its influence over the judiciary, that cannot be democracy. And Dr. Kisaakye is justified in stating there is a problem. So the judiciary should not just shy away or run away from this issue. It is a concern that they ought to give an answer and a practical solution. No, you remember I was counsel in a second lead actually counsel in a presidential election petition number 1 of 2021 filed by the Honorable Robert Kyagulanyi Ssentamu, which we withdrew for having presumed bias or having seen apparent bias that the Honorable Robert Kyagulanyi Ssentamu did not believe he would get justice in that matter. You remember that the Honorable Justice Kisaakye was the judge on the panel, Justice of the Supreme Court, who was on our side. And for having been on our side as petitioners, she faced the wrath of the head of that court. And ever since, that court has not been the same. The rest is history, how her file was confiscated, and how that decision was not made by the entire quorum. You recall we told Ugandans that we do not have a decision in the presidential election petition number 1 on the applications before that court. We do not have a decision because quorum to court is not in numbers, that 3 against 4. No, the entire quorum has to make a decision in one way or another. But that the Honorable Justice Kisaakye was disabled from making a decision, then we do not have a decision of that court. And it may sound funny, but we had an illegitimate government in the last 5 years because the decision which returned Yoweri Kaguta Museveni as president was out of a court that lacked quorum in the decision. But we see that that pattern led to Justice Kisaakye being haunted and hunted down personally, to the extent that she's now in exile. This does not stop with such people. It has gone down the lower levels. You know for certain that the president of the Uganda Law Society is in exile. You remember that lawyers like Nicholas Opio and others have been in exile under similar circumstances. Lawyers who have matters in public interest. Lawyers in politically related matters. Most recently, you've seen beyond the supporters of NUP, beyond the leaders of the party, being the ones now arrested, abducted, and arraigned in courts on trumped-up charges. Now it has gone down to the lawyers. When we decided to go to perform our functions as lawyers at the home of the president, the Honorable Robert Kyagulanyi Ssentamu, you recall one of our colleagues was detained and charged for nuisance. So if lawyers can now be charged for nuisance as they go about their instructions or execute their instructions, then you can imagine what will happen to an ordinary Ugandan. Political leaders are hunted down and abducted. Judges like Kisaakye are going to exile. President of the Law Society is in exile. Lawyers are also now being hunted. Then who is safe? Your guess is as good as mine. No one is safe in this Uganda. And unless we all perform our respective obligations. Let the lawyers do their work. Let leaders do their work. Let the civil society. We shall not get all results from the European Union, not to discount the role of foreign relations, but the duty and obligation is on us Ugandans to liberate our country, liberate ourselves from what is prevailing today. It was with supporters, it went to the leaders, it went to the lawyers, now it is with the judges. Who is safe? No one is safe.